Hi, and welcome back to this week's Tip Tuesday. Thank you so much for joining us. This week's Tip Tuesday is going to be on another form that you may sign in a real estate transaction, and it is the Representative Capacity Signature Disclosure. You can see the form popped up next to me. There are two separate forms that could potentially apply to your situation, whether you are a buyer or a seller. The forms are pretty much the same, but it just is depending on which party is signing, the buyer or the seller. So the purpose of this form is to identify who the principal is in the transaction and who has authority to sign on behalf of the principal. So all of the other disclosures and agreements will be signed by this person that has the representative capacity. For example, you would use the seller form if you are the seller that is listing a property, maybe it's in a trust. Or another example is you are a buyer that's representing a corporation. Those are why there's two separate forms, because there's for seller representatives and then there's for buyer representatives. But the forms itself are spelled out pretty similarly, so I'm going to go over that with you. So in section 1 of this form, it outlines 4 different options that you can check. The first one is, like I mentioned in the example, a trust. So if John and Jane Doe had a trust set up and the home that they are selling is in the trust, for example, the Doe Revocable Family Trust, Joe and Jane are the ones that can sign on behalf of that trust. So the first box you would check is the trust, you would put the trust name, and then the authorized signers would sign at the bottom. The B option is an entity, for example, a corporation, an LLC, and the signers could be the officers, managing members, partners, etc. So the C option is if there's a power of attorney, someone that has been authorized to sign on behalf of another person, maybe the actual seller is out of the area, out of town, and so they have someone overlooking it and signing on behalf of them. A thing to note about that is you will need to have a power of attorney already executed. This form is not a power of attorney in itself. And the last option is D, estate. But you would check whether the seller is an estate, a conservatorship, or a guardianship identified by a superior court case. And you would spell out the name of the case and the case number. Something to note about all of these 4 options is that whichever one is selected and applies to your situation, there will be additional documentation that needs to be provided. Escrow will require it and your agent will require it for their file, and that's just proof of whatever it is. So if you are truly a signer on behalf of a trust, we would want to see a copy of just the trust section where it notes you as the authorized signer. Same thing with a corporation. They might require your articles of incorporation or your statement of information. Those would have who can sign on behalf of that entity. Power of attorney, you would need an actual executed power of attorney, a copy provided to your realtor and the escrow, proving that you have the authorization to sign on behalf of another person. And same thing goes for the last one, if it's an estate, guardianship, or conservatorship. The second section of this form is where the authorized signers will sign acknowledging that they are authorized to do so. And the last section is acknowledgement of receipt. So for the listing side, when you're signing a listing agreement on behalf of a certain entity, then the listing agent would sign acknowledging receipt of this representative capacity. And it would also be signed by the buyers on the second page once there is an accepted offer. So that way the buyers are acknowledging that they know that the signer is authorized to do so. The only difference in these 2 forms is if you're a buyer that is authorized to sign and purchasing on behalf of someone else, then the acknowledgement of receipt by the other party would be different. The seller who's selling the home to you would sign acknowledging that you are authorized to sign on behalf of the buyer, and also the brokers. So hopefully that wasn't too complicated and answers your question, but just to summarize, the representative capacity form that is filled out is just another documentation acknowledging that there is someone signing on behalf of somebody else. If you have any questions about this subject, please feel free to let us know. We are happy to answer your questions. Thank you so much for tuning in to our Tip Tuesday today, and we look forward to seeing you next Tuesday.